Пані Тетяно, вітаємо вас
Tetiana, welcome.
на другому етапі
Welcome
до вищої
at stage 2 of the selection for HQCJ, the interview stage.
Конкурсна комісія проводить
The selection commission in its full composition will be conducting your interview. We are Robert Burgheisen, me, Ivan Mishchenko, Ivan Mezentsev, Steven Markman, Serhiy Varlanov, and Ted Zazhechny. The rapporteurs during your interview are Serhiy Varlanov and Robert Burgheisen.
Якщо наша з вами співбесіда
Should for any reason your interview be interrupted, it will be resumed on a different day and at a different time.
вона була перервана, якщо
We will start from the moment where we stopped.
члени комісії будуть ставити вам
The
запитання.
commissioners will be asking you questions, and we are asking you to be precise in your answer. The commissioner who's asking you a question has the right to limit the time for your answer.
Власне, початком
But before we start with the questions, we will give you the floor for self-presentation. You can tell us about your motivation and the ideas that you have about HQCJ and the judiciary in general. With that, I'm passing the floor to my colleagues. Robert, Serhiy, you're welcome. Thank you, Mr. Chair. Good afternoon, Tetiana. So I will briefly introduce you. Tetiana Pertsova was born on the 18th of February 1975. You have a degree in law. You graduated from Yaroslav Mudry National Academy of Law. And you started working in August of 1997, working as a legal counsel since May of 1999. Until March of 2007, you worked at Kharkiv Regional Department of Justice, holding different positions. Starting from March of 2007, you were appointed as judge of Kharkiv District Administrative Court, and at the moment you are working at the Second Administrative Court of Appeals in the city of Kharkiv. On multiple occasions, you participated in the Congress of Judges of Ukraine as a delegate. You have the general experience of working in the field of law, which accounts to 23 years, and you've been a judge for 14 years.
Будь ласка, пані Тетяна, комісія вам пропонує буквально на протязі 5
So you will be given up to 5 minutes to tell us more about your motivation, explain why you have applied for this selection. Good afternoon, dear commissioners. Good afternoon, members of the audience who are watching us online. My name is Tetiana Pertsova. I am a judge of the Second Administrative Court of Appeals. I hear cases as part of a panel of judges. We are hearing administrative cases. I have the experience of working at Kharkiv Regional Department of Justice, and there we dealt with mass media, different political parties. I also worked as a trial court judge. I have the experience of hearing cases both individually and within a panel. Throughout my career, I have heard more than 20,000 cases, and I have the experience of occupying administrative positions. In my motivational letter, I mentioned inefficiency of measures aimed at ensuring independence of the judiciary and its proper functioning based on principles of the rule of law, which did not result in expected outcomes. And let me explain what I meant by that. So the government, represented by its parliament, increase the salary for judges, which definitely contributed to enhancement of independence of judges, but that wasn't efficient enough. And as an example, we can look at the law of Ukraine on corruption prevention and the mandate of an ACP. So here we are talking about judges who were on their positions until the year 2010. And an ACP was given the mandate which included control functions over the judiciary, namely monitoring and control of judges, influencing their activities. And that is something that NACP could do with regards to judges. They could draw up protocols on corrupt actions in order to hold a judge accountable. We are talking about administrative punishment. And at the same time, the lawmaker, when introducing this mandate for NACP and other bodies of the executive government with special status, did not single out the category of judges, the judges of the Constitutional Court of Ukraine, taking into account the principle of independence of the judiciary. The principle of checks and balances can limit the judiciary. And here we must look at amendments to the Constitution of Ukraine and the procedures of individual responsibility of judges. I think that it's unacceptable that political bodies can control the activities of the judiciary, while the Constitution of Ukraine says otherwise. And we also can refer to the decision of the Constitutional Court of Ukraine of 2020, which includes the norm from the law of Ukraine on corruption prevention. So the declarations are a requirement for people who are civil servants and who are public figures. Definitely, public figures should file their declarations of income, but if we look at the principle of independence of the judiciary and the importance of ensuring actual independence of the judiciary, such declarations and their inspections should be conducted taking into account the principle of the independence of the judiciary. I support the control that is done by civil society, but this kind of control should be done by a respective part of HQCJ and not some civil society organizations. In such a way, we can enhance the independence of judges and prevent any type of pressure on judges. As an HQCJ member, should I be appointed, I will be selecting those candidate judges who are apolitical, who have relevant knowledge, because I'm for quality justice, starting from trial courts. I will be supporting judges with integrity. Quality of justice is something that we are lacking, and as a judge of an appellate court, I see it and I realize it. The increase of unreasoned, unmotivated judgments and other factors mentioned in my motivational letter altogether motivated me to participate in this selection, to be appointed as a member of HQCJ. And should I be appointed, I will take all the measures possible. I will use all my experience to select professional judges. That's if we are being brief. Thank you, Tetiana. Let us now proceed to the questions that our commissioners have for you. So we will start with those questions that we were provided with by civil society organizations. Namely, you did not indicate in your declaration for the year 2012 the information about a land plot, a residential house located in the city of Kharkiv that are owned by your husband as joint property. You also didn't mention Nissan Petrol that your husband has owned since 2008, and also civil society organizations mentioned that in your declaration for the years 2012 and 2015, you failed to declare the following property. A trailer that your father owns a garage located in Kharkiv region, town of Lubotin, that your father has owned since 2003. So what can you tell us about this? So let's start with your first question about me non-declaring some property in my declaration for the year 2012. It was a mistake. I did not declare this property, but starting from the year 2013, in all my property declarations, and I mean declarations for the years 2013 through 2015, I declared this property. And it was connected with the fact that my place of registration was not in Kharkiv. That is why, by mistake, I believed that since I was registered at a different place, I believed that indicating this information was unnecessary. Thank you, that's clear. That's the answer to the first question about the land plot and the house. Now let us discuss the trailer or the car. The car was not declared only in 2012. In 2013, I already declared it. On the same grounds that you did not declare the other property. Now let's talk about the trailer and the garage. As far as the trailer is concerned, it was not supposed to be declared in that declaration because it was not subject to registration. It wasn't registered. My father just had it, and by mistake, I believed that I needed to include it into the declaration. But then I found out that I needed to include the information about its registration, and it appeared that it was never registered. And we haven't had this trailer for many years. So your father had the right to use that trailer, right? Yes. And as far as the garage is concerned, I've already provided explanations about the garage when I was passing my qualifications assessment. And the explanation has not changed. The garage has been alienated on the basis of a sale and purchase agreement. We all know that ownership means the right to own, use, and dispose of something. And my father is neither the owner nor the user of the garage. So, on October the 13th of 2002, the garage was sold to Miss Orlova based on a sale and purchase agreement, which was notarized, and private notary of Kharkiv district confirms that this notary notarized the agreement, and there is no information about the dissolution of the agreement. Thank you, Tetiana. That is clear. Your answer is understandable. Your father sold this garage to another person. That is why you did not mention it in your declaration for 2012 and 2015. My next question is also based on the certificate provided by civil society organizations. According to the judicial dossier, your husband, starting from November the 24th of 2015, has been working with NABU, and they are assuming that your husband was living in Kyiv, but in your declaration for the years 2015 and through 2017, you did not mention any real estate that your husband would have the right to use to. Can you please explain this fact? I did not indicate the place of residence of my husband because my husband was living in the barracks because he was completing the service. Can you hear me well? Yes? Yes? So according to provision 82 of the explanation provided by NACP, if we are talking about real estate of a family member of a person filling out a declaration, if we mean some kind of a military unit or dormitory, this is not the type of real estate that should be reflected in the declaration. And then my husband acquired the right of use to an apartment with the area of 29 square meters located in the city of Kyiv. The apartment is owned by Ms. Boyko, and I can inform you that this information was not reflected in the declaration filed for the year of 2018 because as of the year 2019, my husband was no longer using that apartment. Thank you. Thank you for the answer. The next question again comes from civil society organizations, and they are saying that according to mass media, you were a part of a panel of judges of the Second Administrative Court of Appeals, and as part of that panel, in the year 2021, you made the decision in the case of reinstating of the former Berkut officer, Special Force Berkut, Viktor Shapoval, and Mr. Berkut abused his position, which resulted in killing or wounding of 113 Maidan protesters in the city of Kyiv. Could you please explain this? Yes, I was a member of the panel of judges that heard this case, and we left the decision of the trial court unchanged, which reinstated this officer in their position, so there were no political motives of him participating in legal or illegal protests in the city of Kyiv. We are talking about some procedural aspects. That's the first thing, and the Supreme Court refused to initiate proceedings. So the decision was left unchanged, and the Supreme Court agreed with your decision. Yes, that's clear. Thank you. I will now pass the floor to Mr. Bruggeisen. Robert, you're welcome.
Thank you. Ms. Pertsova, when you would be appointed in the HQCJ and there would be a candidate for the position of judge, and such a candidate would have quite a lot of questions about the declarations. Because civil society says that there were mistakes in the declarations. What would you do with such a candidate? Do you hear me?
No?
Well, I will think first of all about the consequences, whether there are any negative consequences of such actions, whether he was really trying to hide his material status, his financial status. And I will judge by the facts, by the actual circumstances. It depends on what exactly was not reflected in the declaration, what the amount of this property or assets was, and what the consequences of this were.
So what you say is that when you are in the HQCJ, you will look at if there are any assets missing. And if the mistake is serious, you may have a look at it. And if you find it not so serious, you will say, well, not too bad.
Well, not exactly not too bad. The point is that Until certain time, the declarations were to be filled, but there were no explanations from NACP. There was no common practice as to what should be reflected in the declarations, what should not be reflected in the declaration. So it all depends on the period, on the year when the data was reflected or was not reflected. If it happened after 2015, because I will be assessing declarations filled after 2015. So I will be taking into account all the actual circumstances in the case.
Okay. When you had your, let's say, opening statement, you said that because of what is said in the constitution of Ukraine and in the constitutional law, you feel it's a bad idea that it is civil society who has opinions about declarations, and that this should be the HCJ who would make such conclusions on basis of such declarations. That's correct, eh? I understood that correctly.
Not exactly.
No?
In my introductory speech, I meant that the executive branch of power should not exercise control and pressure over the judiciary, while the public should be involved in all the processes, because this is one of the principles of independence
Okay,
in a democratic society.
so
The public should be involved in all the processes and should be heard.
okay, so maybe I did understand it incorrectly. So what you say is that you think it's a good idea that civil society is involved in the assessment of the declarations provided.
Yes.
And that it's no issue at all if they make remarks about such declarations, as they did with you.
Well, they can express their remarks, their reservations, and their voice should be heard. And I should provide the answer.
Okay, because when I listened to you, I thought you said that it should be the HCJ, the High Council of Justice, who would deal with the declarations. That's what I noted down.
HCJ should do this, but it should involve the public. But now it's the executive authority, the national agency, that is doing this. That's what I meant.
Okay. The reason I'm asking the questions is that you discussed a lot the word independence. It's in the Constitution. The judiciary should be independent. And I keep on thinking when I hear those lines that independence should something that you should earn. To be independent, it should mean that at least you should be trusted, and then you can be independent. And the point is, however, that the majority of the people in Ukraine do not trust the judiciary. So maybe the independence has not yet been earned. What's your view on that?
I think that anyway, there should be a public control, but at the same time, we should follow the norms of the Constitution that clearly separate the legislative, executive, and judicial branch of power. And it is independence that is achieved through the fact that the executive power cannot be exerting pressure on the judiciary. And I think that the public here is not on the side of the executive authorities. The public, the civil society, is on the side of the society, which is in another side.
Okay, thank you.
I think that we should differentiate between independence and arbitrary will.
I don't understand that.
I mean that that judges should be independent, but it doesn't mean that they are independent from the law, that they can do whatever they can and exert their arbitrary will.
Okay. Agreed. Ted?
Yes, thank you, Robert. Justice Pertsova, when I read through your motivation document, which of course answers the 10 questions we ask all candidates, there's one theme that is repeated over and over again. In fact, there are two themes. One is independence, and the other concern is improper influence. And among other things, you make the statement, the acute issues which need to be solved, in my opinion, are the measures which would make impossible the influence of other institutions, representatives of legislative, executive bodies, and local authorities on the independence of the judiciary. Now, what would you suggest should be put in place in order to safeguard members of the judiciary from this undue outside influence?
I think that the necessary amendments should be introduced into the Constitution of Ukraine and into the law on the judiciary, and they should be related to the activity of judges. Since, you know, they are declarative for now, they are not enforceable. And if the representative of executive authorities do understand that their illegal pressure or intervention will really lead to some negative consequences, irreversible consequences for them, and not in some 10 years when this person loses the position, but right away, immediately, if this is done not in the way established by the law. So I think that they will keep from such actions.
Are you suggesting, if I understand you correctly, that it should be made a crime in Ukraine for anyone to unduly influence or pressure a judge?
Well, you know, in fact, we have it even now in the criminal code. But I would say that these are declarative statements, and they are not enforceable in practice. Not a single civil servant or official has been ever brought to account for such things.
And that actually brings me to my next and perhaps final question, and that is interference with judges still a significant problem in Ukraine? And do you have personal experience with this?
I will try to give an example to answer this question. Last year, the Circuit Court of Kyiv was liquidated. Liquidated just one day, and that's it. Yes, there were some problem issues related to some judges of that court. And I think that this issue could be settled in a different way. These judges could have been brought to account, including criminal account. Why liquidate the whole court? And the consequences were bad, not just for the judges who had something to do with certain criminal actions or illegal actions, but scrupulous, good, and competent judges were also affected by that. They were left out of court. They were deprived of their position. So what about their safeguards? What about their guarantees? And a lot of people who had filed lawsuits in that court were also affected by this decision, because in the nearest future they will not have their case settled because the number of cases there was really high. And the cases are to be transferred, and they are still being transferred for consideration. So in paper it was written that the cases would be heard within a short timeline, but practice shows that they are still not transferred. heard. And they still have to be appointed for consideration for hearing, and people need to get restoration of their rights because that's why they addressed this court. And there are a lot of cases like this. So the consequences are bad for judges, good judges, and for people in general.
Yes, I'm not talking about the liquidation of that court. I'm talking about whether or not you have had any personal experience with the kind of improper influence, or are you aware of any members of your court who have had improper influence?
While hearing certain high-profile cases, in particular related to election law, because, you know, these cases are to be heard by administrative courts. So while hearing those cases, we have high likelihood that there will be some pressure, some intervention. So to prevent this from happening, not to face this experience, not to wait for this to happen, you need to consider to hear this case very, very quickly, for no one even to have time to try and intervene. I mean, representatives of executive authorities. So you need to kind of prevent that.
Well, that's not my question. My question is, have you personal experience with interference with your independence as a judge?
Well, personally, I did not experience any of such pressure or intervention because I do not communicate on those issues. I communicate with trial participants only throughout the day when the case is being heard and not out of court.
Right, and are you aware of any concerns that any of your colleagues on your court have expressed about undue influence?
Every year, we have to submit by the 31st of January the Declaration of Integrity and the Declaration of Family Relationship. In the Declaration of Integrity, judges have to indicate whether there has been any of such pressure on them or not. Maybe some of them have indicated this, I don't know. And this is not the issue that is disclosed to colleagues. We do not speak about this in the open. And therefore, I cannot tell you who of my colleagues has faced this and who has not.
Yes, we ask, or at least I have asked somewhat similar questions, and I have yet to have any judge say to me, in answer to such questions, that they have been subject to undue influence, or that any members of their court, to their knowledge, have been subject to such influence. So because your motivation letter is so preoccupied with this question, I wondered what was the basis for your concern?
Well, that is just open information. Now we have High Council of Justice already functioning, and they considered such messages about interference. So that's where from I know about such cases.
I see. Thank you. I'll pass the questioning to my colleague.
Hello, Judge Pertsova. Thank you for participating in our competition. I think you said something very important a few minutes ago, and I'd like to call attention to it. You said that the judiciary is not independent of the law. I agree with you completely. That's a very important proposition. Is it fair to say that judges are entitled to independence and they're entitled to deference by the other branches of government when judges themselves act in accord with the law? When they act in accord with the law, they're being deferential to the legislature and the executive. Is that a fair trade-off?
Yes. If they act in accordance with the law, they have this right then to be independent from other branches. But if they make some violations, they should be brought to account, but individually, not as a whole court. I mean, there should be individual responsibility for every judge depending on the action committed.
Judge Pertsova, you also talk in your motivation about the concept of what you call corporate solidarity. And as I understand it, that's a term or a phrase describing the relationship between members of the judiciary. My question is, could you elaborate a little bit upon what you mean by that term, corporate solidarity, and more specifically, solidarity in defense of what, and solidarity against whom? Solidarity usually communicates that some group of individuals is standing up in defense of something, and there's somebody who is coming to attack, I guess, to use that metaphor. What do you mean by corporate solidarity, Judge?
Well, there is some corporate solidarity in the sense that judges must have some common rights and duties. They participate in some processes and procedures which are the same regardless of the jurisdiction of the court and of the judge. They consider court cases, they pass decisions, and they are united by some specific interests of the judiciary, and they are taking care of meeting this interest. So that is what corporate solidarity is. I mean that they have to build their standpoint in the way to support the reputation of the judiciary. That's what I mean by corporate solidarity. To support it, this is supporting or maintaining independence and reputation of the judiciary. But let me stress it once again that this is not independence from the law, but independence from illegal intervention and pressure. But at the same time, if I see that, or if I see in the future that, well, there is a judge and this is my colleague, but he or she has committed a wrongdoing, it will not be possible for me to show corporate solidarity in respect to him, because just because he's a judge and I have to close my eyes to his actions and not to respond in the way I actually am supposed to under the law.
So again, solidarity connotes to you that it's solidarity in defense of a judiciary acting in a proper manner. It's not solidarity no matter what the issue is, no matter what the judge has or hasn't done. It's solidarity in defense of a proper exercise of the judicial power. Okay.
Yes.
I'm looking at your motivation, Judge Pertsova, and you say in, I think, point 8, nowadays society has a somewhat negative attitude to courts and judges. I'd say that's an understatement. But you say there's a somewhat negative attitude to courts and judges overall. The acute issues which need to be solved, in my opinion, are first of all the measures which would make impossible the influence of other institutions. Isn't the better, first of all, really that we try to cure what it is that's caused the negative attitude toward the judges in the first place? Isn't that really the proper priority? Let's find out why people have these negative attitudes, try to correct those institutions and those actions by the judiciary that have caused those attitudes, and then we can focus upon defending the independence of the judiciary after we've corrected some of those flaws. Do you have the right, first of all, in other words, first of all being that we have to make impossible the influence of other institutions? Isn't, again, the first of all that we try to understand what the problem is that's caused these public attitudes of distrust?
Well, I think that this can be done in parallel. You can be at the same time advocating the independence of the judiciary and at the same time rectifying the mistakes and the negative elements of the judiciary that caused this wrong perception by people. Why wait?
But do you understand my concern about those three words, first of all? Society has somewhat negative attitudes to courts and judges, and therefore, first of all, we have to make impossible the influence of other institutions. It may be a subtle point, but just wondered if you had any second thoughts upon the emphasis of the first of all. Let me move on to another question that my colleague Judge Zarzechny raised a few minutes ago, having to do with criticism of the courts. You say that we need the setup of mechanisms which would effectively help implementing principles of the judicial system and their functioning by practically preventing defamation of the court. Well, you know, when you go into public service, isn't that kind of something you purchase? You purchase the kind of criticisms that you're going to get from the public. I've been in the public. My colleagues have been in the public on the judiciary. We've all received criticism over the years as part of what you get for being on the judiciary, for being in public service. What do you mean by practically preventing defamation? Are we talking about civil service not being able to defame, ordinary people not being to defame, or somebody within government not being able to threaten the court in some way? I don't understand what kind of defamation you're focused upon and what you would do about that so-called defamation. Could you please explain a little more clearly?
Well, I think that there must be more transparency in the decision-making process, and there should be more communication with the public. Not the way this is happening now, at the moment, from time to time. There should be some regular contact, regular communication for the judiciary to explain via its speakers the content of certain typical decisions or high-profile decisions in high-profile cases, because a person is always concerned about things that are hidden or that are not understood. But if we introduce more openness and transparency in this respect, for example, a decision has been passed. Maybe it's not perceived well by the civil society or by a certain strata of the society, some category of residents, some group of people, for their own considerations. But we need to explain why this decision has been passed. We need to kind of explain the motives. And the fact that, well, I think that it's right. Let's get back to this mechanism of declaring. It's correct that we have declarations. It's correct that people can see the salaries of judges, their standard of life. And this leads to more openness. And the society if the society knows the information, it understands why it happens so and is not trying to invent things. So there will be no defamation then.
But you're in a...
But if we don't do anything at all, the situation will just remain the same. There are always some people who are dissatisfied with the decision. There will always be such people. There are cases when the suit is not granted, is not satisfied, and the person, of course, can be dissatisfied. But if the decision explains quite well why this decision has been passed, and the person reads this out, probably she will understand.
Well, you're certainly correct that there's always people around to criticize our decisions. I've been an appellate judge like you're an appellate judge, and I've never had a case in which there wasn't a winner and there wasn't a loser. And the loser always wants to criticize, or often wants to criticize. And the press might call me up and say, well, what do you have to say to this criticism? Our ethical rules basically say, I spoke in my opinion. Would you like, you speak about openness, maybe the openness would give you more authority to speak in defense of your opinion than we have in our system. Is that correct? Should that be the rule? There's always going to be losers, and they're always going to want to blame you for the loss, right? So are they defaming you when they disagree with you? Are they doing something inappropriate when civil society says your decision is a bad decision and you didn't understand this or you didn't understand that? What practically do you think that private people and organizations like civil society should be able to do when they don't like your decisions? I think that's the question that I believe Judge Zarzeczny and I are trying to get at.
Well, I will not tell any new things now, but I think that to avoid this defaming, we should have some training, some seminars for civil society organizations, for them to know what they can do, what they cannot, for them to better understand the decisions. And we should do this on a regular basis, maybe via some publications. And now we have the judges, speakers, who actually cover the activity of courts in certain directions. So whenever we are covering and highlighting this activity, we could at the same time explain the grounds for certain decisions, and maybe that will partially remove this high level of dissatisfaction among people. And they will not label you, they will not have this defamation. I would say that now we don't have this surge, this wave of dissatisfactions with the decisions of trial court judges.
But you've just raised my final question. You say we should have seminars and maybe civil society could attend so they can know what they can do and what they can't do. That's kind of the question I'm trying to ask you. What can they do in your view and what can't they do? What should they be able to do and what should they not be able to do? What are those seminars going to teach them in that regard?
Well, for example, representatives of civil society could be present even in the court hearings in appellate courts, and that is the way it happens sometimes. They do come because we have open hearings, and they are staying in the courtroom during the case consideration. That is also helpful. Suppose we would have roundtable discussions, it would be possible to somehow prepare some information on the issues they're interested in, some relevant issues that are high-profile issues, so to say. We could explain the motives why certain decisions could be passed in that way, why they are grounded and motivated.
Yeah, well, thank you again, Judge Pertsova. I appreciate that. Let me move on to my colleague, Judge Verlanov.
Maybe for me.
Oh, that's not you.
Okay. Доброго дня, пані Тетяно.
So, good afternoon, Tetiana.
Звертали уваги на необхідність правильного заповнення.
You have mentioned a number of times how important it is to fill out the declarations in a proper way, and you have been asked a couple of questions by Judge Verlano. So far, all the questions we had concerning your electronic declarations, well, the cost of Nissan Rogue of 2018, it has been clarified, the issue has been removed. It was about $9,000. And according to the data from Facts, the American website on the sales of cars, their latest rate was 7,100. So no issue with that. In 2013, your husband purchased Toyota Land Cruiser 200 of the year 2011, and at that time it was a 2-year-old car. The declared value was $25,000, but along with that, even now, 10 years have passed since the date that your husband bought this car, and the value of this car in the market, there are 46 Toyota Land Cruisers 200, is from $26,000 up to $40,000 for the most expensive car. So on average, it is $33,000. Now, 10 years ago, your husband bought it for $25,000. What is the reason for such low price? Well, the point is that you have the documents that showing that on the 26th of November 2013, my husband bought Toyota Land Cruiser, and on that very day, Toyota Highlander of 2011 was sold out. Now, concerning sold out, it's clear. Concerning the money for the acquisition of the car, we don't have any problem. The issue is only about the value of this car, because even now the least expensive car like this costs $26,000, and your husband 10 years ago bought it for $25,000. As of the date it was acquired, the value was determined on the basis of the fact that the seller of this Toyota Land Cruiser 200 on that very day got from my husband Toyota Highlander. So we just paid the difference between these two cars and their cost. And the documents available in the electronic dossier actually confirm this. This happened on the same day. We just paid the difference. Okay, I understand, but Land Cruiser could not actually cost $25,000, so it should have been indicated that what the cost of the Highlander is plus $25,000. So the real value of Land Cruiser is not $25,000. So you should have indicated it. But we spent $25,000. And what about Toyota Highlander? What was the cost of it at that time? About $350,000 hryvnias. Okay, you provided some explanations concerning the circumstances under which your father bought a house in Louboutin for 299 square meters in 2019. And we would ask you to provide oral explanations, because it's quite a relevant issue, and civil society says that there were some miscorrespondences. So what were the circumstances under which this house was bought, and what was the money for that? Where from? It was not acquired, it was built. It was built in 1991. But it was put into operation in 2019. And why such a long period was the period when it was not put into operation? Well, I reflected this residential house, in my declarations as ownership all the time. When I worked as civil servant, I didn't know it was not put into operation. It was clarified only later. That's what my parents decided. Okay, clear. Thank you. It was not in order to hide something away. It was in my declaration. Okay, clear. And you have mentioned, as far as fighting defamation is concerned, that we should prevent this negative phenomenon. Suppose you are a member of the HQCJ and you have to make qualification assessment of a certain judge, and the judge voices harsh criticism against the activity of the commission and your activity in particular within this assessment procedure. What would be your response to such a published statement? Well, do you mean that he does it in public, in mass media, or in some social media? Yes, and this is absolutely harsh criticism of the current evaluation procedure, your individual practice, practice of the HQCJ in general. He says that he was not allowed to submit certain documents or something like that. So this is harsh criticism of the whole commission and you as a rapporteur in his case. Well, in decent terms, but this is anyway harsh criticism. If this is done in public, this is a public statement that has come to be known to the public, probably on the website of the High Qualification Commission, we should somehow make a statement on that and explain that a person disagrees with something, he may go to court to appeal the decisions. What other sort of reaction could there be? No, I'm asking you. I'm not suggesting my own solutions. You are to give the answer. It would be just quiet reaction. The scoring of candidates, of judicial candidates, what do you think of this system, the current system that we have for this election? Is it absolutely perfect, or probably we should quit this system in favor of, well, let's say testing and interviews like this one, testing general skills, testing, checking the instrumental vetting of integrity, and plus this interview. What would be better? And could the scoring really reflect professional competence and integrity of a judge, of a judicial candidate? Well, I think that any assessment is subjective. That's why there will always be someone who loses and who will not be satisfied with the result. And he or she will raise the issue of how the scoring was performed, how the place in the ranking was established. There will always be a person like this. So I think that efficiency is something that corresponds to the current practice, modern practice. And so far, scoring is the most efficient method. But anyway, there will be some people who are dissatisfied from the people who have lost. So I would not take into account the response, whether people are positive or negative about it. Thank you. No more questions, dear Mr. Chairman. Thank you.
Пані Тетяна,
Tetiana,
в якомусь сенсі продовжу.
in some respect, I would like to continue with the questions asked by my colleagues, but let me try to do it from a little bit different angle.
Твердження перше.
Statement number one.
Довіра судової системи, довіра до
Trust
судової
in
системи
the
в
judiciary
суспільстві низька.
among the society is low. You know that the level of trust is
Під час
low.
співбесіди
During the interview,
ви казали про
you
те, що
have mentioned
треба організовувати
that
круглі столи.
there should be some roundtable discussions, some seminars, and judges, speakers should be more active on regular basis.
Має працювати декларування.
The mechanism of declaration should be fully functioning, and you have mentioned a number of other
Але
things.
ж все це є.
But we have all this in place. Why doesn't
Чому
it function
завдяки цьому
properly?
всьому не
Why?
підвищується довіра
The
до
trust is something easy to lose and not easy to revive. This cannot be done overnight. And the measures that have taken place and that are being introduced, as you know, have been in action not for a long period of time yet. That's why it's not possible to restore the situation, to restore the trust within a short period of time. It was happening for years that people were losing trust. So how can this trust be revived within several days, months, or years? They should feel it after they go to courts and that will take time. And so far, the people who are addressing courts, in many cases, are satisfied with the work of courts.
Ну, як мінімум половину не задовольняють.
Well, at
Як
least
мінімум
half of them
половину
are
не задовольняють, тому що
dissatisfied
вони
because they
програють.
lose cases. Well, you're right, of course, but we need time. This cannot be done overnight. We need to cherish some culture, some attitude to the judiciary. Trust cannot be revived at the click of the button.
А чому вона була втрачена?
And
І
why
чи
was
була
it
вона
lost?
колись?
And did we have any trust at a certain point of time? I think we had. When? Well, judging by the fact that civil society was not that much dissatisfied some 15 years ago, 20 years ago, I think that maybe 20 years ago we did have some trust in the judiciary. So what did we do wrong?
Чи не ми, а взагалі, що таке сталося, що ми,
So what
як
happened?
Україна, її
What did
розгубили?
Ukraine do wrong to lose this trust? Well, I think that the attitude to people was bad, and that's why people are dissatisfied. Probably people didn't get the protection they were trying to find from courts. They saw some events that caused indignation. There were some phenomena that should have been eradicated while no one did this. And there have been cases when addresses were made to the High Council of Justice asking to have some people dismissed, but they were not dismissed. Maybe if they were, the events would have developed in a different way.
Ясно, я вас зрозумів.
Okay, clear, I've got
Скажіть,
you.
будь ласка,
Your point.
як ви відноситесь
What is your
до
attitude
того, що
to the
у
following?
суддів є профілі в соцмережах?
Courts,
Вони їм потрібні?
judges have some profiles in social media. Do they need them? I don't have a profile in social media, but in case you don't publish there any information that undermines the reputation of the judiciary, I don't see any problem about having an account in social media. But I don't have my profile because I don't have time for that.
Скажіть, будь ласка, ну, всі ми
Okay,
знаємо про
clear.
те, що судовій
You know,
системі не
we all
вистачає
know that the
значної кількості
judiciary
суддів.
lacks a lot of judges. There are a lot of vacancies that have not been filled
На ваш
yet.
погляд, чи є
What do you think?
представників якої саме, скажімо так,
What are-
юридичної професії не вистачає?
What is the
суддів,
legal
суддів,
profession, the representative of which we lack the most?
Чи
Scientists,
перевага має
academicians,
бути надана
lawyers, attorneys at law,
помічникам
or
суддів,
assistant
можливо,
judges
тим, які зараз працюють у
who are
судах?
currently working in courts,
Чи це взагалі не актуально? Як ви вважаєте?
where this is not relevant? When I was appointed a judge, there was no special training at all. And I didn't work as assistant judge before that. But this did not prevent me from mastering this profession and, as I think, to adequately administer justice. So I would not say that it should be only attorneys at law, only scientists. No, I don't mean only. I don't mean only, of course, but I mean the most.
А от, наприклад, там надати,
Suppose
ну, якби надати перевагу саме
we
цим
should
категоріям, чи ні, чи
give
в цьому немає
preference
сенсу?
to certain categories, or is it pointless? Well, I would not give preferences to any of these categories, and I don't think that they need any preferences. Suppose assistant judges know much more than lawyers, attorneys at law, scientists who have nothing to do with the process from that side of the barricade as a judge. I would not give preferences to them, but we need to take it into account that there are some conditions, some criteria. And now we have this staff problem in courts. So in case this will accelerate the procedure of filling the vacancies with professional staff, professional judges, probably we could apply a differentiated approach to this matter. But generally, I am not in favor of giving preferences to any category. Everybody should be on the same terms, in the same conditions. Thank you, it's clear. Are there any other questions to the candidate?
Не будуть? Пані Тетяна, наша
So,
співбесіда
Tatiana, our
добігає
interview
кінця.
is going to be
Будь ласка,
over
як ви
soon.
її
Please try to
підсумували?
wrap
Що
it
такого,
up, to sum it all up.
важливого,
Maybe you have
ви
something
бажаєте
important
підкреслити
to
чи
add or to
сказати,
stress at the end of the
не тільки
interview
членам конкурсної комісії,
for
а
the
й
members of the
дивляться.
selection commission and
Будь ласка,
probably
вам
for
слово.
the public as well. The floor is yours. Well, to sum it all up, I would like to say that I understand that selection of judicial candidates is a very important mission. And well, since I started in Kharkiv Regional Administration of Justice, and since I went along my sudden career, I have got experience of communicating with different strata of the society at the professional level. And I will be able to use this experience while holding interviews with the judicial candidates in case I become a member of the HQCJ. 3 of my assistant judges have become judges already, which means that I also have an opportunity to, and I can actually select professionals. I think that work in the appellate court within the panel of judges for a long period of time, and these were different people in different times, shows that I can claim that I have the experience of communicating with colleagues, and this will come to be handy for me if I become a member of the HQCJ. I'm sure of my standpoints, of my statements. It is based on specific norms, and I'm ready to advocate my standpoints and statements to the HQCJ, trying to convince and to persuade them that these statements are right. In case there will be some disagreement, I can voice dissenting opinions because I have such experience in my career. And I think that the fact that I have passed qualification assessment as a judge and qualification for the judicial position of the Cassation Administrative Court at the Supreme Court, where I confirmed my ability to administer justice, but I didn't get enough score, so my ranking was too low to pass. But that has provided me with experience that will also be useful for me as a member of the HQCJ. And I'm grateful to the Selection Commission for the important and relevant questions. And I do believe that it will select the most professional and decent candidates out of all those who are participating in this selection procedure. Thank you.
Дякуємо вам, пані
Thank you,
Тетяна.
Tatiana.
Наша співбесіда
Our
з вами
interview
завершена.
is over.
Дякуємо за неї.
Thank you.
До побачення.
Goodbye.
Всього вам найкращого.
Good luck and
Бережіть себе.
stay safe. Thank you. Goodbye.